how are you?
Good, how you doing?
Good. So I'm covering for Attorney DeCroce today. So you're scheduled for a sentencing hearing today on the disorderly conduct, and then you were scheduled for a trial on the breach of bail charge, right? Is that what you have as well? Okay. So what we're going to do today is we're just going to go forward with the sentencing hearing. I'm not going to go forward on the breach of bail. You were convicted on the disorderly conduct. I don't see a reason to pile additional charges onto you. So you'll be sentenced on the disorderly conduct, and then we'll be done today. Okay?
So you're dropping the breach of bail?
I am. Yep. Okay. And I spoke with the trooper about it, and he's fine with that. Okay?
Thank you so much.
All right. Sound good?
Yeah, no problem.
All right.
Welcome back, everyone. Today's case is one of those sovereign citizen courtroom disasters you really can't make up. We've got Frank Staples, a self-proclaimed First Amendment auditor who thinks yelling at government officials in their own front yards is constitutionally protected speech. Spoiler alert, it's not. This is the kind of defendant who confuses freedom of speech with freedom from consequences. And that confusion is about to earn him one of the most chaotic sentencing hearings you'll ever witness. On one side, we've got the prosecutor, calm, collected, and ready to cut through Frank's circus act with a laser of facts. On the other side, Frank, a man who believes the louder he yells, the stronger his case becomes. He's representing himself, because of course he is, and you'll see exactly how well that goes.
Pretty dead, Frank.
Yeah, well, I mean, there's no way. I got the law right here, right? So I didn't create a danger, obviously, which is why this has been dropped, and I didn't commit a felony, okay? I'm being persecuted for exercising my first...
Getting angry, didn't you and I just didn't we just have
Because I'm here today for nothing. That's why I'm getting angry.
You're here for a sentencing hearing.
Yeah, I know. And I got found guilty of disorderly conduct for less than what I'm doing right now.
Okay.
For being loud. Because I have a loud voice. So I got found guilty of disorderly conduct for having a disability because I get excited and
Here it comes, the classic sovereign citizen defense. Notice how Frank immediately reframes his criminal conviction as persecution. This is a common tactic. Instead of acknowledging the actions that led to the charge, he paints himself as the victim of government overreach. But let's be clear, he wasn't arrested for speaking his mind in a public forum. He was arrested for showing up at a government official's private home, screaming so aggressively that the police were called. That's harassment, not protected speech. Question for you guys. Do you think sovereign citizens actually believe their own arguments, or are they just hoping to confuse the court long enough to dodge consequences? Drop your thoughts in the comments, because this case is textbook.
And you had your day in court.
Oh, and I was found guilty, yeah. I had my day in court, and what was I found guilty of? Why am I not under arrest for disorderly conduct right now?
Sir.
Why am I not under... Hey, listen, don't give me no directives. You're just going to make it worse. Ridiculous.
Hey, Frank.
Absolutely ridiculous.
Frank, was the breach of bail when they arrested you here? Was that one, or was it a different one?
Judge is on the way.
Yes.
We'll wrap this up and you'll be on your way.
That was the one, thank you. That was the breach of bail for the New Hampshire 9 arrest. For where someone was arrested for saying amen. And I was arrested for, we don't know yet, making a loud noise, which is all on video, and I didn't make one fucking peep. Not one fucking peep.
You know, we would know if you had.
You're in a courthouse.
I don't care. It's not illegal to swear. Okay?
If you
I don't need,
disturb
listen,
other
have me
people-
arrested. Do something. Do something.
I don't want to.
Do something. Because you can't.
I'm trying to
Don't
work with
give
you.
me directives and tell me what to do or what to say or anything.
Frank, come on, Frank.
I'm trying to, but these people, they all want to take their time. Oh, hey. Oh, just calm down. Let it be cool. No, this is absolute bullshit why I'm here today. And everybody knows it, and that's why you dropped those charges.
I told you why.
So I get it. You're cool. You dropped the charges. I appreciate that. It's nothing personal against you.
Then be
This
cool
is
with me
business.
because I'm being cool.
I am being as cool as I can be.
Frank.
Okay?
Come on, Frank.
You want to get this done?
Oh, I'm ready. Let's do this thing. I've been here. Let's go.
Defendants will enter.
All right, honorable court is now in session.
All right, good morning, everyone. Thank you. Please be seated. All right, and this is State versus Frank Staples, docket number 435, 2021 CR 240, and dockets number 435, 2021 CR 1692. Attorney Jaworski does appear on behalf of the Newfields Police Department. She's filling in this morning for Attorney DeCroce. Mr. Staples does appear. He is self-represented. We are scheduled this morning for a sentencing hearing in the 2021 CR 240 on the Class B disorderly, and then additionally the matter is scheduled for trial in the breach of bail charge. Are we ready to proceed?
Judge, we're going to go forward on the sentencing order. As I told Mr. Staples, the state police are here. I had an opportunity to speak with them. Although we are ready for trial, I think in the interest of fairness and equity, he's been convicted of the underlying disorderly conduct charge, so we're going to use prosecutorial discretion.
How is it underlying?
And here's the problem with Frank's logic. He argues, why am I not under arrest right now if I'm guilty of disorderly conduct? This is the equivalent of saying, I can't be a criminal unless I'm actively committing a crime in this very moment. That's not how convictions work, Frank. Disorderly conduct isn't some perpetual state. It's about specific actions on specific dates. The jury already found him guilty for what he did in the past. That doesn't magically reset because he's calm or relatively calm today. It's this kind of circular nonsense that makes these cases both infuriating and entertaining to watch.
Prosecute the breach of bail charge, and we're just going to go forward on the sentencing hearing with the disorderly
Okay,
conduct.
all right, very good. And then I will give you that one. Oh, wrong one. I gave you that one. This is the breach.
That's somebody different.
All right, thank you.
Thank you.
All right, so with that then, if we're ready, we'll proceed with the sentencing and the state's recommendations. Mr. Staples, what I'm going to do is I'm going to hear from the state first, what they're recommending relative to the disorderly conduct, which was a Class B misdemeanor in that matter. And then after I hear from them, I'm certainly going to hear from you as to any recommendations or any position you take as to penalties, okay? So with that, thank you, Attorney Jaworski.
Judge, the state's going to ask for a $1,000 fine, $500 of that to be suspended for 2 years of good behavior. Your Honor heard the facts and circumstances of this case. This is an individual who has racked up similar charges to this. He has
Don't interrupt
a
them.
prior conviction for bail jumping in 2013, February 11th of 2013. It looks like he had 1 to 7 years for a sentence with counseling, mental health treatment. He had a possession of prescription drugs also in 2013 where he was convicted. He had multiple counts. He received a 12 months time served sentence in that particular matter. He had a possession of a controlled drug with intent to sell conviction in, looks like 2004 out of Hillsborough.
When is my sentence over? When is the crime done?
Yes,
Mr. Staples, please, I'm going to hear from you also.
Yeah.
But she gets to recount what she
Fine.
wants,
She
so
can do whatever she wants.
thank you.
Another possession of controlled drug with a 9-month sentence. Shoplifting conviction in 97.
I was 17! A
Mr.
juvenile!
Mr. Staples,
So she's bringing up my juvenile.
Notice how the courtroom dynamic shifts here. The judge has now formally opened the sentencing hearing, which means everything Frank says from this point on is essentially evidence of his own behavior and credibility. This is usually where a defendant shows remorse or at least tries to minimize damage. But Frank? He doubles down. He heckles the prosecutor, interrupts the judge, and treats the courtroom like his personal soapbox. If you've ever wondered why judges sometimes come down hard on self-represented defendants, this is why. Frank's not just wasting the court's time. He's demonstrating that he learned nothing from the trial that brought him here.
I mean, come on! What's really going on here?
Staples, do I need to take a break? Let's just get through.
Let's get through it then!
Telling me what she wants to recommend and about your
And
prior-
why? Because of all these past crimes all the way back to when I was 17?
All right.
Get the fuck out of
Stop.
here.
And please with the language. Attorney Jaworski.
Judge, he has a robbery conviction in 97 out of Hillsborough South with a 12-month suspended sentence. That's the first half of his criminal record. He does have an additional 6 pages, but I won't go through every. Of an enhanced fine, although I am asking that half of it be suspended for 2 years good behavior. Also, part of that good behavior is that.
Not paying shit. Believe that.
Okay.
Mr. Staples.
Sure, we have the address. They cannot be allowed to respond to that same address with a disorderly conduct occurred, Judge.
Okay, Mr. Staples, you've heard the recommendation of a $1,000 fine with 500 of it suspended. Do you wish to be heard on what you're asking the court to impose within the limits of the maximum amount?
Yeah.
$1,200 fine.
$0.
Hey, Frank, but I doubt the court is going to hand you a fine that matches your IQ. Next.
Because I didn't do anything to cause any sort of pecuniary loss or any damage or anything like that. And I also am asking you to reconsider your finding of guilty, because I will be appealing this. I'll put you on notice. And I do want to know exactly what did I do to commit disorderly conduct, because it was nothing even like what I've been here today in this courtroom. Okay? I didn't do anything that was disorderly. I asked why I was being threatened to be arrested. The man never asked me to leave the area. You've seen the video. He lied in his testimony. So I want to know why I was found guilty to begin with. What? You need to...
This is one of the most damning moments in the entire hearing. The prosecutor calmly rattles off Frank's criminal history: drug possession, bail jumping, robbery, shoplifting. And that's just the first half of the record. You can almost feel the courtroom sink under the weight of it. And Frank's response? He nitpicks the timeline, complains about things from decades ago, and curses at the process. This shows us a lot about his mindset. Instead of taking responsibility, he treats every conviction as an injustice against him. That pattern is exactly why judges and prosecutors don't buy the "I'm being persecuted" act anymore. What do you guys think? At what point should the court just stop giving repeat offenders like this another chance?
Sentence. We've had your opportunity.
$0! No penalty whatsoever!
Okay, thank you. And I've heard your testimony and listened for several hours at the trial, and I've issued that, and certainly you do have the right to appeal, and I will expect you to do that. So with that, I will adopt the state's recommendation. I will impose a fine of $1,000. $500 of that will be suspended for a period of 2 years for your good behavior.
Put me in jail now then, $50 a day. Let's go. $50 a day in jail because I ain't paying shit.
It's 150 now.
So
150, whatever. We do $10 a day. Let's do it.
don't sell yourself short. Are you able to pay the $500 fine? I'm sorry, yeah, $500.
I ain't paying no $500 fine.
All right.
You gotta be kidding me.
So you know there's an additional time payment fee of $25 that gets added?
Don't care. I ain't paying none of it.
Okay.
Ever.
If I put you down, that it'll be paid in full within 30 days, in addition to...
Say whatever you want to say.
That's what I'll do.
Okay? Ain't gonna happen.
We'll be in recess. Thank you. Good
Yeah.
luck to you, Mr. Staples.
Thank you. Have a good day. Bunch of bullshit.
Well, have a bad day.
Huh?
Wish him a bad day.
You got it, yeah.
Amazing. You told her you weren't going to pay, and she's like, well, we'll put you on a time payment.
We'll put you on a time. Put me in jail now!
They don't want to put you in jail.
Let's go.
Put me in jail now! 5 years in solitary confinement, you get fucking fined, $500 fucking fine, get the fuck out of here.
I love how they brought in the
Unbelievable,
SWAT
you bring up all that fucking record too. I've changed my life. I have a fucking business where I help people reintegrate from prison and from rehab.
This is Frank's golden opportunity. The judge literally says, "Do you wish to be heard?" which is the defendant's chance to argue for leniency. Most defendants would use this moment to show remorse, highlight positive changes, or at least argue for a lighter fine. Frank? He argues that the court should overturn the guilty verdict entirely, something this judge cannot legally do during sentencing. This isn't strategy, it's self-sabotage. By refusing to engage with the actual issue, what his sentence should be, Frank basically forces the judge to adopt the prosecutor's recommendation wholesale. It's Courtroom 101. If you don't ask for leniency, you won't get it.
When are my past crimes done with? When do I lay it down? Ever?
You already know the answer to that, Frank.
Never.
Never.
Right?
Let's go. Come on.
We feel it's right around. Bunch of bullshit. Hope you feel real good about yourself.
I don't think I've ever heard of anybody paying fines, any activists. It's funny, they think they get us and they don't.
Let's do it. I love this game. We could play this all goddamn day.
They just want to bring him back in for another hearing.
Yeah.
That's what they want.